How do pre-existing conditions affect workers' compensation claims in California? In California, the workers' compensation system is designed to provide benefits to employees who are injured on the job. However, what happens when an employee has a pre-existing condition? Understanding how these conditions can impact workers' compensation claims is crucial for both employees and employers. What is a pre-existing condition? A pre-existing condition refers to any medical issue that an employee had before suffering a work-related injury. This could range from chronic back problems to old injuries that were aggravated by workplace activities. The key question is whether the work-related injury has exacerbated the pre-existing condition. California workers' compensation law does provide coverage if a work-related injury aggravates or accelerates a pre-existing condition. This means that if your existing condition worsens because of your job duties or a workplace accident, you are entitled to workers' compensation benefits. However, quantifying the extent of aggravation and proving that the workplace incident exacerbated the condition can be challenging. When filing a claim involving a pre-existing condition, you will likely undergo several medical evaluations to determine the impact of your work on the condition. The evaluating physicians will need to differentiate the symptoms of your pre-existing condition from the effects of the work-related injury. This distinction is crucial for determining your eligibility for benefits. What are some challenges in proving your work comp claim? Proving that a work-related injury has exacerbated a pre-existing condition involves demonstrating that workplace activities or an incident had a definite and measurable impact on the pre-existing condition. This often requires detailed medical records, expert testimony, and clear evidence of the change in your condition following the workplace injury. Given the complexities associated with claims involving pre-existing conditions, consulting with a workers' compensation attorney can be very beneficial for your claim. An experienced attorney can help navigate the medical evaluations, gather necessary evidence, and advocate on your behalf to ensure that you receive the appropriate compensation from your employer or your employer's insurance company. Workers in California with pre-existing conditions should understand their rights under the workers' compensation system here. While these cases can be more complex, with the right approach and professional guidance, affected workers can successfully claim the benefits due to them. Understanding the terms AOE and COE in the California workers' compensation system. Navigating the complexities of workers' compensation claims in California can be daunting, especially when it comes to understanding specific legal terminologies like AOE and COE. These acronyms stand for arising out of employment and course of employment, respectively. They are critical in determining whether an injury or illness qualifies for workers' compensation benefits. What does AOE and COE mean? In the realm of workers' compensation claims, for a claim to be valid under the California system, the injury or illness must arise out of employment or occur during the course of employment. This dual criterion ensures that the employee's injury is directly related to their job duties or occurred while they were performing those duties. Arising out of employment. This element addresses the origin or cause of the injury. An injury arises out of employment when there is a causal connection between the injury and the work that the employee was performing. This means that the nature of the job or the work environment was a contributing factor to the injury. What about course of employment, or COE? This refers to injuries that happen while the employee is engaged in activities on behalf of their employer. Essentially, it focuses on the time, place, and circumstances under which the injury occurred. For example, if an employee is injured while at work during working hours and performing a task related to their job, it likely occurred in the course of employment. Understanding arising out of employment, or in the course of employment can be best illustrated through these examples. An employee who slips and falls in the workplace while performing their job duties has an injury that both arises out of and occurs in the course of employment. Conversely, if an employee is injured in a traffic accident while commuting to work, this typically does not meet the AOE or COE criteria because commuting is generally not considered part of the job, unless the commuting is part of the employee's job duties, such as in the case of a delivery driver. Why AOE and COE matter? The distinction of AOE and COE is crucial because it determines eligibility for workers' compensation benefits. If an employee cannot prove that an injury is connected to their job duties or happened while they were working, they may not be able to receive workers' compensation benefits in California. This can include medical treatment costs, lost wages, and disability benefits. AOE/COE determinations are not always straightforward and sometimes lead to disputes between employees and employers or the employer's insurance provider. In such cases, the specifics of the incident are critically examined, often requiring legal interpretation and evidence review. Employees may need to provide substantial proof or documentation that supports their claim that an injury is in fact work-related. For employees in California, understanding the concepts of AOE and COE is essential when considering filing for workers' compensation claims. Recognizing what these terms mean and how they apply can greatly influence the success of a claim and ensure that injured workers receive the benefits that they deserve. Employees facing challenges in proving AOE and COE may find it beneficial to consult with the workers' compensation attorney to navigate the claims process and advocate on their behalf. If you need help with your work comp claim, please call my office at 323-545-6858.